plans. We're gonna get started in a second. Just so you know, the chat is gonna be open the entire time, and the Q&A is gonna be open the entire time. So I got plenty of questions. I'll set the chat up, but really this is an opportunity for you all to ask Nico questions directly. That he was going to provide as much context to as possible. So that's how we're going to run it. Unfortunately, our camera's not working still.
No, it's not. I apologize. I don't know what the problem is.
That's all right. We're going to make it the voice only Nico, but it's a very
Okay.
nice voice that you have, so it'll be okay.
All right. It's too
So
bad. I
it'll be
bleached
okay.
my hair and everything, you know? Oh, well.
That's all right. So, thank you for joining us. We're gonna roll with it this way. I appreciate it. So when this injunction came out about a week ago, Nico, you're my first call partner, Shepard Mullen, been working with many of the people involved in this law for many decades on other environmental work that they've done. So we have a lot of questions for you about what has happened, what's going to happen. Before we get into that, I want to really quickly set the stage for everybody with a little bit of context here. So I'm going to walk through for a minute and just share like the history of this law and what went down and where we're at. And then we'll use that as a jumping off point because I know some people here have been following it for years. And for some people, I sent them an email a month ago and they're like, oh, a law. Great, let's do it. So folks are in different places here. So let me explain where we're at. So we're going to talk about this as the California Climate Package, SB 253, which requires companies over $1 billion to measure their carbon emissions. Sorry, yes, their carbon emissions, and SB 261, which requires companies with over $500 million to talk about their climate related financial risks. These laws were introduced in early 2023 and then signed into law on October 7th, 2023, by Governor Gavin Newsom. They were signed into law over 2 years ago as this package here. And almost right away, litigation opened up against them. So the U.S. Chamber of Commerce and many others filed three lawsuits against them. I'm going to ask Nico to define these for you a little bit more, but they were about the First Amendment, the Supremacy Clause, and the Dormant Commerce Clause. I've got a little typo there. The Dormant Commerce Clause is what we call a New York City lawsuit. The Dormant Commerce Clause. And then basically these laws continue to evolve, but two of these lawsuits were struck down. So the Supremacy Clause and the Dormant Commerce Clause were basically shut down or rejected. And then over the course of this year, the California Air and Resources Board has done a lot to try to give information to the public and to companies who might need to comply about what they have to do. They ran multiple workshops. You see these injunctions were denied, so there's a little bit more certainty provided. They put out FAQs and multiple checklists and ran multiple workshops throughout the course of this year to try to give a lot of transparency and context as to what is going on with these laws. And then last Tuesday was a very fun day because while CARB was giving yet another workshop trying to give yet more guidance to these laws, the Ninth Circuit Court of Appeals issued what is called a temporary injunction, basically staying enforcement, saying that this January 1st deadline may or may not really be a real deadline. And so SB 253, that carbon emissions law with compliance deadline of August 10th, I believe, for the companies that are subject to it, that remains in effect. That was not touched. But this SB 261 is temporarily paused by the Ninth Court of Appeals. So, Nico, feel free to comment if I got something very wrong there. But my real question for you is how, like, the nuts and bolts of how is this possible? How is it possible that a law that has been a law for 2 years or was signed into law 2 years ago, now we are 36 days away from this compliance deadline, and all of a sudden it is paused? What happened in the interim or what went wrong to get us to this point?
Well, it's a very interesting procedural history, and you gave a pretty good overview there. Let me just add a couple of details to that. So that August decision so first, as you mentioned, the first two claims, the Dormant Commerce Clause and the Supremacy Clause claims, were final orders were issued denying those claims by the district court, but it kept alive the third claim, which is a First Amendment claim, and that basically argues that these laws are unconstitutional because they compel companies to engage in political speech. That's the argument. The state responds that no, it's just factual information. It's not political speech. So that's the question, and it's a live question. The district court held that it's going to have to go to discovery and ultimately to trial. Um, and the chamber filed a motion for a preliminary injunction saying Okay, we're going to appeal that decision, but while we're appealing it, please enjoin the laws. Don't allow them to be implemented while it's pending before the Ninth Circuit Court of Appeals. And in August, the district court said, no, we're not going to do that. And it's a 41-page decision, and it's a decision only a lawyer could love. It goes into all kinds of details about the level of scrutiny that is involved and whether this is factual speech or not, etc. And interestingly, it holds SB 261, the climate-related financial risk law, to a higher standard of scrutiny than 253, because 253 really is, it basically agrees with the state. That's just data. That's just emissions data. Whereas climate-related financial risk, that requires analysis, right? That requires some judgment calls as to how a company is going to identify its risks and mitigate that risk, et cetera. So that was held to a higher level of scrutiny, but the court nonetheless held that on balance, they think that the standard for a preliminary injunction is you have to show to get one that you have a greater likelihood of success on appeal. So we're going to win on appeal, Your Honor. So you've got to stay this decision until we get in front of the court. And the district court said, no, I don't think you're going to win on appeal. So denied it. They then appealed to the Ninth Circuit, Court of Appeals. And interestingly, at the end of October, they again requested an injunction pending appeal, and the Ninth Circuit denied that at the end of October. Right? So you think, okay, it's going to a merits panel. It's been fully briefed. It's going to go and just have a regular appeal. The hearing, as you noted, is on January 9. Well, the plaintiffs' appellants didn't stop there, and they said, okay, then we're going to seek an emergency order from the United States Supreme Court, and that they filed in early November, just a week before the Ninth Circuit handed down its decision last Tuesday. So why did the court switch course? It had denied it before. Why did they issue it now? It's a one sentence order, so it's not explained, but I think reading between the lines here, it's pretty clear that the Ninth Circuit was concerned that the U.S. Supreme Court was going to step in and grant that emergency appeal and maybe take up the case on the merits in so doing. And they didn't want that to happen. They wanted to keep it in their court. And so they gave the half measure of enjoining 261, but not 253 pending the resolution of the appeal. Okay, so what is the impact of that? Where do we stand? That's kind of the background. How do we get here? And now we know probably why, but what does this mean? Um, there's been no ruling on the merits, right? There's no ruling on the merits. So the statute remains on the books. That January 1 deadline remains on
So
the books.
basically, no one said like that argument. But really quickly, before we talk about the
Yeah,
merits, I think it'd be helpful to talk about those three cases that were brought: the Dormant Clause, the Purpose Clause, and
claims,
the
not
First
cases,
Amendment
claims. Yeah.
claims. Excuse me, claims. This is where my plebeian knowledge fails me. But can you define those three things and then why the latter two were dismissed, if that's the right word, and why the first one was still being held out in court?
Sure. Very briefly, the Supremacy Clause says that where the federal government is regulating something, it's supreme. It governs. So the federal law governs, and if there's a state law that says 55-mile-an-hour limit, well, just to take some simple example, that was a federally mandated rule, right? And if the state says, no, we want to make it 100 miles an hour, state cannot do that. The federal law has supremacy over the state law. And so they argued that the federal government, through the Clean Air Act, is alone responsible for the regulation of greenhouse gases. This is a de facto regulation of greenhouse gases. Therefore, it's enjoined by, and the federal law governs. And the court said, no, first of all, this isn't about greenhouse gases. It's about data. It's about, and information. It's not, I mean, California has its own laws regarding greenhouse gases. That's different. That's not what this is. So the federal law doesn't apply here.
It's basically saying like have high emissions, have low emissions, have great like just tell us what they are. We're not making you
Exactly.
reduce them. We're not making you buy carbon credits on them. We're just saying tell us what they are.
Exactly. Exactly. And the Dormant Commerce Clause is basically it's a related doctrine. It's not it's called dormant because it's not the Commerce Clause is in the U.S. Constitution. The Dormant Commerce Clause is not, but it's kind of been read into it. And the argument there is that where a state is de facto regulating out-of-state entities, then the Dormant Commerce Clause kicks in. So California, and there was an important Supreme Court case a year before last where California, the voters had adopted a law by initiative that requires producers of pork to provide humane treatment to the pigs. And the Pork Council, the National Pork Council, sued under the Dormant Commerce Clause saying, hey, California is regulating the production of pork in Iowa and in other states. And you can't do that, California, because you can only regulate in California. And the U.S. Supreme Court said, no, no, California is not doing that. And it upheld the law, basically saying that they can do what they want with regard to the meat sold in its stores, and they can do what they want. And that was a very important ruling because that really kind of took the legs out from a lot of the Dormant Commerce Clause cases that have been brought challenging various climate rulings, actually, and some have been successful around the country. But with that,
And that's interesting because that's a big one that I actually hear a lot from companies I talk to. They say, "Ah, I think this is crazy. California is doing this. We're a 700 million global revenue business. We have one office in California. We have some customers in California, whatever. Like crazy that they're forcing us to do this." And I guess what you're saying is what the courts decided is they're not forcing you to do this. They're saying if you want to keep that office or keep the customers in our state, then please do this. But if not, like feel free to not do business in
exactly,
our state. We're not making you do this by virtue of being an Iowa company or a New York company. We're making you do this because you are in our state.
exactly, exactly. And so that doctrine, that claim was thrown out. But what survived the challenge in the district court was the First Amendment claim, whether or not this is compelled political speech or not. And that's the case that's now pending before the Ninth Circuit.
And
And
the argument there basically being like, you are making me, California is making me state something that is not confirmed, which is talk about climate change, which is like not a confirmed factual issue. You're making me share opinions I might not have. Is that
that's
is that
right.
the case?
That's right. And again, remember the district court um, held 253 to be, pretty clearly factual information, and that they were pretty clear that's definitely not gonna you're not gonna win on the First Amendment on 253. 261, yeah, you got more of a case there, and
Mm.
that they were going to allow that to go forward. And I think the Ninth Circuit's one sentence ruling reflects that same kind of differing analysis.
Is let's at least hash it out. Like let's see
Right.
where this lands on the appeal. I've talked to you before about this First Amendment clause because it's been on the books, or this case has been going on for a long time. And our conversation, the conversation I've had with many other people, is that I think the argument makes sense. I think forcing companies to talk about climate change, whether it's confirmed or not confirmed, like it's not less of an opinion issue, but it's more of the fact like I guess the context of it is really murky. But what never made sense to me about the free speech case here is that I never read it as them forcing you to say climate change or man-made or even that it's real. Like I think if you want to issue a report that says we did an analysis and we actually think the climate isn't changing at all, it's going to be the same today as it will be in 40 years. So therefore we don't think our risks increase at all, then that'd probably be okay if that's what your analysis shows, right? So it always seemed like the other ones almost seem stronger to me than the free speech one. But explain to me the strengths and weaknesses of the free speech case as you see it.
Well, the strength is that I mean is just that. It's compelling people to speak about climate change, companies to speak about climate change, which is, they contend, a political issue, not a simple factual issue. And it is, many, as we know, contest it. I mean, our president contests it, says it's a hoax. So they're saying that you're forcing us to engage in it. And secondly, and this is a big part of it, the real motivation here is to seek to embarrass companies by getting them to say out loud we don't believe in climate change, for example, or something to that effect. So that's why they're saying it as that it is political. But you're right. I mean, it calls into question the very, whether or not climate change is real or not, right? I mean, that's why they consider it to be political speech. and compelled political speech with the purpose of embarrassing them. And the state says, well, no, first of all, it's not political because it is real. And investors have a legitimate right to know what you're doing about it, if we're going to invest in your company or not. And where the district court pointed out that in some of the state's filings, they go beyond that. And they do sort of say, yes, this is to educate investors. They have a right to understand this. And we also think that this will help to achieve our emissions reduction goals by getting companies to focus on climate issues. That's where it starts to sound a little bit more like compelled action and not just free speech. Um, Not just, providing information to investors.
Mm.
So the state has kind of walked a line there that undermines their case a little bit. But the thrust of the case has always been, and the thrust of the laws has always been, investors have a legitimate right to know what companies are doing about this very real risk that they face. Are they going to be here in 50 years if their
Yep.
office is right next to an ocean that's rising or something like that?
We'll come back to this topic in a minute of like, what do you actually think will happen? How are you advising clients? There's a question from the audience that's a good one, and I'm going to share something in a moment to add some context to it. But someone in the audience asked, is there any risk or penalty if we stay the course and proceed to publish the climate risk report by January 1st, 2026? As we think about that, Nico, I also want to share two slides here that I found interesting. I've been reading what every law firm puts out about this news, and there's been a theme that's emerging, which is basically like, look, this pause is real. We don't think this either. They're saying like we're not it's on shaky footing. We don't think this will be upheld, and we think this law you're going to be forced to be compliant, or at least the risk of this law being upheld is such that you might as well have all your ducks in a row, and you should just continue to prepare for this thing, and then see how things shake out. Whether you publish on January 1st because you want to, or you wait until after January 9th or after whatever we hear the results. I'm not sure about that yet. Give us a couple weeks and we'll think about it, but we should at least have everything ready. So you see, I bolded here, but DWT, Cooley, Debevoise, Ropes and Gray all basically said, like, you should do the work. Now, on the other hand, you'll also find a wonderful group of perspectives that are basically, I should have added more here to even it out, but basically saying, like, it's not a statutory deadline, so why would you do the work? You don't need to do it because it is not the law anymore because it is temporarily paused. So, what's actually going to happen here? January 9th is the court case. It takes 3 weeks to deliberate it. Maybe in early February, they're like, all right, worst case for these companies, I guess, like worst case, they say, great, the law is in effect. California's not going to go back and say, let me see the timestamp of you uploading it on February 1st. Realistically, they're probably going to give you a few more months. So you kind of see both of these things depending on which law firm's insight you read. I'm curious, Nico, kind of break that down and how you're talking about it with clients about what might happen after January 9th and how should companies think about preparation. And then we can tie that into the audience question about what is the risk of publishing by January 1st. Anyway.
Sure. Well, I think there's actually a fairly consistent theme through those different law firm statements, and frankly, and it's not different from mine, which is you should, regardless of how the court rules, and we can get to that in a moment. The the fact of the matter is that yes, it is stayed right now. The January 1 deadline is stayed, so that's not in force. There's no requirement right now that companies post their disclosures, SB 261 disclosure reports on January 1 to their websites. That law remains on the books. And so if the court decides to uphold California's laws, then immediately springs back into life. And so you best be ready in case the state says, hey, January 1 deadline, that's now in force. So if the court should come out with a ruling on January 10, which it's not going to do, I'll come back to that, then you could be faced with a very short deadline to post your report. So my counsel to clients is to continue preparing your report and be ready to publish once the court rules, if in fact it does rule to uphold SB 261. To respond to the question, though, should I go ahead and post? Is there a risk, a downside risk, if I do post it on January 1? And yes, there is a downside risk. I think it's a pretty remote one, but it really will depend upon what you say in your report. The risk that you face is a greenwashing claim. If you make unsupported claims about achieving net zero by 2030, and you don't have any of the metrics and any of the strategies that it's going to be able to achieve that goal, it's just a net zero pledge with nothing behind it, you could be subjecting yourself to a greenwashing claim. So that's the risk, and it really will depend upon on what you say in your disclosure report.
That's interesting that you cite that as a risk. You think that's more of a risk than the risk of like over disclosing your risks, and now all of a sudden investors know that they should be asking you about your business continuity plan in the face of hurricanes because you mentioned that for the first time in your TCFD report. You think greenwashing is more of an issue than like all of a sudden you have more transparency, especially for private companies, more transparency than you've ever had before?
Those are risks as well. Both are risks. As to which is greater, it will really depend upon the
Depends
situation.
on what you say and the company itself. Yeah. Are there benefits to doing it? Like if
Sure.
I'm going to my boss, my CFO or my chief legal officer, and I'm trying to make the case that we should publish on January 1st, what would that case be?
The case there is that you're ahead of the curve. You're a very, responsible corporate citizen, and you're addressing this issue, and you've got a plan, and we're on top of this, folks. And you should invest in us because we're on top of this. We have a good handle on how we're going to handle this risk. We understand what it is for our business, and we're addressing it. And we're good corporate citizens because we have a strategy for how to ensure that we are sustainable going forward.
Got it. So the argument to do it is we're ahead of the curve, regardless of how this law comes out. Maybe on January 10th, we'll have to do it anyway. Maybe the whole thing goes away, but another jurisdiction will have to do it. Or maybe we just believe the trend is going this way. And so we follow the law that is written, and here
Right.
it is. Where let's lead on this. And the risk of doing it is if it turns out that this law goes away and no other law will ever impact you, and you put your foot in your mouth with something that you say then you may not have. You probably should be very careful what you're saying, regardless of whether there's a law or not. You should double check what you're actually writing. But I guess the argument is if you never would have had to say anything, then why did you? Would be the con to doing so.
Right, right. I mean, and remember, the TCFD, began in the voluntary realm, and people have been
Mm.
making these disclosure reports voluntarily for quite some time, and without the compulsion of law. So, all of those factors, the pros and cons, were already at play in the
Yeah,
voluntary space. So,
yeah. I mean, thousands of companies, well before these laws came out. I think the number is 4,000 companies have issued voluntary TCFD aligned reports.
mhm.
Most of these very large companies, some a big chunk of these European companies, but almost 1,000 American companies had issued climate risk reports before these regulations. You could find all these metrics inside like the TCFD. I think in 2021 they issued their most recent assessment. So you're not totally going out on a limb here and doing something
Not at
new.
all.
Excuse me. But that makes sense. You were probably about to touch on this next anyway, Nico, but somebody asked a question, so we'll set you up with it. But when is the court likely to issue its ruling? It sounds like it is unlikely to be on January 10th. What is the procedural stuff of what happens next?
Yeah, and this is where we get into a bit of the realm of speculation, because there are no deadlines. Courts, they get lifetime tenure and and they don't have deadlines the way the rest of us do. So it's scheduled for oral argument on January 9. Now, technically, the court does not have to have oral argument on January 9. They could just say, we'll decide on the papers alone. Given the high profile nature of this case, I'm pretty sure that they will go forward and have oral argument on January 9. Now, it's possible that they will already have made up their minds and they will have written their decision, and the oral argument will just be performative and not have any
That's
impact.
possible. They could write these arguments without ever hearing the arguments,
Yep.
or they could write their. Okay,
It's
there you
unusual.
go.
It's
What do
very
you think for the day?
unusual.
Yeah,
Because, there's always
it's
a chance that some lawyer, brilliant lawyer, if they hire me, I'll make some new argument that'll be brilliant, right? So,
yeah.
um, you
That
know,
feels like my parenting strategy. Before my daughter asks for the third popcorn, I already know what I'm going to say here, but go ahead.
Right,
Before
but
oral
you let
arguments
her
are made,
ask
I
anyway,
understand.
right? You let her
Yeah,
ask.
yeah, she'll ask, and she gets her appeal. And sometimes I do cave.
So there you go. So,
Okay, that makes sense. So go ahead.
while it's technically possible that the court could issue a ruling on January 10, it's very unlikely. They're going to consider the arguments that will be made at the oral argument in addition to those that have already been made in the briefing. And okay, so then when are they likely to issue their ruling? It can take many, many months. They could take months and months. Given the deadlines, given the fact that the ARB is fast developing, well, not fast, is developing regulations to implement the laws, and given the high profile nature of the case, my guess is that this decision would be issued in a matter of weeks rather than months. That's just pure speculation. We'll see how it goes, but I would expect that we would have a decision by probably the end of February, would be my guess.
Mhm. And what are the options for what that decision might be? The versions I've heard is decision one, law deemed unconstitutional, it all goes away. Decision two, law deemed constitutional. You better have published on January 1st because that was the law, and you are now out of compliance if you didn't do that. And option number three is probably a version of option number two, which is law deemed constitutional, but then CARB comes out with guidance and says you have 6 more months or 1 more year to do this because we can't go back in time and make you do this. Those are the three options I've heard. What are they actually?
A little bit of variation on that. First, it's important to understand that what is pending before the court right now is a facial challenge to the laws, which is meant just the laws on the books as written are unconstitutional, and you don't need to dig into the facts of the matter at all. And particularly with regard to 253, the district court said, nah, because in fact, the way the statute is written, it doesn't direct companies to do anything. It directs ARB to do things, to develop laws and develop regulations rather, and to develop requirements. So, you don't have standing to say anything about that. It's up to ARB. But to get really more to the heart of it, if they find that it's unconstitutional on its face, but they could find that, but there is a valid claim here for an as applied, for as it works out with the regulations actually out and how it's actually going to impose actual requirements on companies. That may get into an area where it starts to be unconstitutional. And for that, we're going to say, motion denied. We're not going to give you the preliminary injunction, but we think there's enough here that we're going to send it back to the district court to go ahead and have discovery and have a trial, which is, by the way, what
Mm,
the district court was going to do, right? They didn't, the only reason why it's up on appeal now is because of this deadline and it's kind of an
yeah,
emergency.
they just didn't get it done in time.
Right. So you could have the result that ARB is authorized to continue making the rules and to continue going forward and to continue imposing deadlines for disclosures. And by the way, that August 10 deadline for 253, that's their current thinking. It was June 30. Now it's August 10. We'll see when they actually issue their proposed regulation, what date they come down on. It's got to be in 2026, but they could push it all the way out to December 31 if they wanted to for 253. But we'll see when we get the actual regulation. Right now, they're saying we're targeting August 10.
Mhm.
So we'll see when they get. So ARB could be good could go forward with its rulemaking, and at the same time, the case could be remanded back to the district court to have a trial and to have discovery and a trial about whether or not these now regulations are going to actually force company A to engage in political speech.
That's incredibly confusing to me. So let me make sure I understand this. So what could happen, and maybe is not an insane possibility considering this is the direction things were headed on if it wasn't under these timelines, but let me repeat this back to you and tell me where I'm wrong here. What could happen is that the court says CARB has the authority to publish these regulations, and the law gave CARB this authority. So CARB says, yep, January 1st, maybe it'll be nice and give you a month buffer, but like go out and put these things on your website. And every company is going to listen to CARB and put these on their website. But at the same time, the case of whether this law is constitutional or is compelling speech will continue on, and that could take months or a year or however long these things take, and that could all be canceled later on, or like it feels like
Yep.
they're both going to have that both of those things are going to happen at once, and I'll both be regulated into doing this, and also there's going to be a remaining case against it.
That seems odd, but yes, that's exactly that. That is definitely one scenario.
This is why I did not become a lawyer. We can agree that makes no sense, or am I missing something?
No, no comment.
Okay,
It makes
all
sense
right.
from a lawyer's standpoint, but that
It
doesn't
makes
mean
sense from a
in the
lawyer
real
standpoint.
world.
There's a couple dozen attendees here who I imagine are on my side on this one. Feel free to ask questions, folks. Keep chiming in. Kind of partially tied to this, I'm going to share one last slide that I have here. And you brought this up a little bit, actually, in the very beginning. Your opening line, you talked about how maybe the timing was strategic because, the chamber basically said a couple weeks ago that they might go to the Supreme Court and ask for
Good
some
for the
relief
Supreme Court.
here. And we sort of know what would, or we assume the Supreme Court would not be particularly friendly toward these laws. And so maybe, as you see, the National Law Review published that this decision by the Ninth Circuit could have been interpreted as a defensive move to avoid immediate review.
Yeah, exactly
Cooley
how I
says
view
again that these plaintiffs have been generally unsuccessful to date. So they're not necessarily saying what they think will happen, but they're saying like they've lost all the other ones. So the Ninth Circuit probably thinks they would lose this one too. I'm going to talk about this Dwayne Moore's line in a minute because this is probably how everybody feels, and as well said here. But it is your opinion that this is the Ninth Circuit basically being strategic of like we don't want the Supreme Court involved. We think the Supreme Court will be quickly biased against this. We're going to handle it in San Francisco on our own turf.
Yeah, I mean, yeah, there's two parts of that. One is just protecting their turf, and then the other is, reading into it a position on the merits. So I think it's more the former than the latter. That is the Ninth Circuit saying, "Hey, this is our turf. We want to decide this. It's pending before us. Don't take the case away from us." I think that's the main issue here. That's setting aside the legal merits of it. But it's hard to set aside the legal merits. I mean, given this
Yeah.
the nature of the Supreme Court and and we don't know, this is an important point. The Ninth Circuit, the way it works on appeal is you draw a three-judge panel out of what is it, 30 judges on the court. You draw a three-judge panel. You don't know what three judges you are going to get until the date of the oral argument. So you don't know. So those could be three Trump
Hmm,
appointees. They could be three Clinton appointees. We don't know. So that will go into the identity of those judges may give a little insight as to what
that's
the
interesting.
rationale was.
Who selects them, or are we pulling out of a hat?
It's basically pulled out of a hat.
Okay, that's exciting. It's a wonderful uh, way for me to plan for my future.
Yeah. I mean, you
Okay.
saw that play. I mean, in general, the Ninth Circuit is viewed as a more liberal circuit court than
Mhm,
the Fifth Circuit in the South.
mhm,
It's generally viewed that way, but
mhm.
there are some very conservative judges on the panel as well. And we have seen in the Ninth Circuit, we have seen judges making public statements criticizing each other about, politicizing some of the decisions during this administration. So
Mhm.
politics is definitely getting involved here in the judicial realm. But
Yeah,
again,
that
but
makes sense.
fundamentally, it's a turf battle.
Yeah. Pete here asked one question, and then I want to come back to the Dwayne Morris line, just mostly to talk about our feelings. But he asked, crystal ball time, does SB 261 survive? And if it does, when will it come into force? Note, this does not constitute legal advice. I, as the non-lawyer, will give you my opinion, which I'll tell you why I think it. But I think it does survive, and I think California CARB says we're giving you a 6-month delay to actually put out your report. And the reason I think that is because I'm not a lawyer, but the free speech thing just seems not very logical to me. Like just on the like, I don't think they're making anybody say climate change is real. I'm not arguing whether it is real or not real. I just think like they're not forcing you to say that. You could issue a report and you can actually find these reports. If you look up Jack in the Box, this is public, but Google Jack in the Box, the restaurant TCFD report, you'll find that every answer basically says we have no risks. We have no risks. We have not done this. We have no risks. I think you could probably say that and be totally compliant. And all right, if your investors agree that you have no risks, you're good. So I don't think they're compelling speech. It feels weird and illogical to me. But another reason is they're really not alone here. Like there's so much precedent for laws like this all over the world. Precedent for this specific law in Europe and Australia and Brazil and Singapore and Japan, all requiring these things. Um, and then, I think plenty of other examples talking about risk management. So for those reasons, I think it does survive, and I also think it would be illogical. And California has pushed back deadlines a lot, but it feels like it would be very illogical for them to go back and say you must have this on January 1st if we're already in February or whatever. Um, but then again, the law says January 1st, so maybe I'm wrong there and they don't have the ability to do that. I'm not sure from a technical perspective how that would work, but this is
They don't.
recorded, so that's my bet. Nico, feel free to share yours.
Well, let
And
me
this does not
address.
constitute legal advice, Pete mentions.
For sure. Well, I'm not going to address that. I mean, I'm happy to come back to it. I mean, I will just point to, on your slide there, the Cooley statement. The plaintiffs have been generally unsuccessful to date. I mean, that's true. And so if you're a betting person, I think you would, stick with that. Remember that the Ninth Circuit did previously deny this very same motion. It was only after it went to the Supreme Court that they issued the order. So, I mean, if you're a betting person, I think you would bet on the side of the laws being upheld, just given this track record and setting aside the legal merits. But to the more immediate question, okay, they uphold the laws. What does that do to the January 1 deadline?
Hmm.
CRB has repeatedly stated that, sorry guys, January 1 deadline. I know we didn't make the July 1 deadline for having
Hmm.
adopted regulations, so we gave ourselves an extension, but we cannot give you an extension beyond January 1 because it's right there in the
Hmm.
statute. And that's true. They don't have that authority. It's in the statute. But the court has the authority. So I am betting that whatever decision the court issues, whenever it issues it, they will probably put in there. And the injunction remains in place through X date, and give
Hmm.
folks a bit of an extension to do that. That would be the responsible thing for the court to do, and I would expect that they would do that.
So that was like we're on the same page. I just didn't have the fancy words to say what I meant.
Well, the difference is that it would be the court granting the extension, not
Hmm.
ARB.
Yeah. So then everybody said, look, we're doing our best to make this January 1st thing happen. The court said you get another 4 months or 6 months or whatever. So what are you going to do? That's the
Right.
court.
And
Right.
same for 253. Right now they've said August 10 as the disclosure deadline. The statute says it has to be in 2027.
Hmm.
So they could push it all the way to December 31. Could they make it
Hmm.
January 1, 2027? No, they cannot.
What would be I mean, the Chamber of Commerce has been a very unhappy camper for the last couple of years. They're really taking this one personally. What would be their options? Let's say this what you just suggested happens, which the court upholds this law and maybe grants a couple extra months. Can the chamber try to sue it again? Can it go to the Supreme Court again?
You
Like,
go to the
can
Supreme
the
Court.
chamber come back? It can.
You would do an emergency appeal to the Supreme Court. And the Supreme Court might take it up.
Interesting. Is that if you were the lawyer to the Chamber of Commerce, would you say, yeah, of course, no matter what, we're going to go to the Supreme Court? Why wouldn't you? Or is there a
Yeah,
reason
well,
why
they
they
will have
wouldn't?
two options at that point. Well, three options. One option is to lick their wounds and go home. I don't expect
Mhm.
that to happen. Option
Mhm.
two is to seek en banc review, which is to say, remember, this would be a decision by a three-judge panel. You can request a review by the entire Ninth Circuit. Now, it used to be that you would get the entire Ninth Circuit would have to take, if they chose, they don't have to, if they choose to grant a petition for en banc review, the entire court would review it. Now it's a larger panel. I think it's 10 judges that are also selected at random. And then that
Mhm.
10 judge larger court would review it and issue a decision, yay or nay. After that, they could appeal to the Supreme Court. Or they could appeal directly to the Supreme Court from the three-judge panel ruling. And I fully
Got it.
expect that they will litigate this as long and as hard as possible.
Yeah, they're really standing their ground here. They don't seem like wound lickers. And I imagine a 10 judge panel doesn't help them in San Francisco or Northern California. So the Supreme Court one feels like it makes sense. Someone asked another question here very related to this. Um, so comment however you like, but they said, is this not a massive infringement on states' rights if SCOTUS does anything other than knock it back to the Ninth Circuit or uphold the law entirely? where does states' rights play into this? Like, can SCOTUS? I guess they. I don't, I'll stop commenting. But is this an infringement on states' rights if SCOTUS does anything but send it back to the Ninth Circuit or uphold the law?
Well, not send it back to the Ninth Circuit because that's a the Ninth Circuit is beyond California. It's multi-state, so it's in
Okay,
state
so wrong.
law. But no, it's a very legitimate point of states' rights. And remember, this same Supreme Court upheld California's regulation of pork products, right? So there is a certain degree of sympathy for states' rights, even in this court. That said, and it's legitimate, and they could say it's a question of federalism. California wants to do this, it can do it. The argument against that, um, aside from the politics at play in the country today, the argument against that from a legal standpoint is certain rights, particularly Bill of Rights, fundamental rights like the First Amendment.
Hmm.
These are, they're as close as you can get in the United States to universal rights, right? They are held by the individuals, they're held by the people, and no government, state or federal, can overrule those rights. So that's why you have a court as the last backstop to protect people's rights. So in that case, it becomes a question of, think back to the civil rights era in the South. It's states' rights, but the argument
Mm.
back is, well, no, these are fundamental human rights, civil rights that these people have to not be segregated. So, we're going to overrule your state's rights.
So if the Supreme Court sees this as a violation of freedom of speech, then that
Right.
that goes back to a version of supremacy. Like it supersedes what California. They'll say California messed up. They violated free speech. That's why the Supreme Court's going to step in and nix it.
Exactly. Exactly.
Yeah.
And that's a real possibility.
Yeah, that makes sense. Really quick, I just posted in the chat, but we have one final. We do this every week. This was a special Tuesday event, but normally the Thursdays at 2 p.m. We have one final Beekly of the year next Thursday. It's just a Beehive product deep dive. So if you're an existing customer, want to know the product better, or just looking around at stuff, that's a good way to get to know us and what we're up to and building in the future. And then the following Thursday, I'm supposed to have a child, so no Beekly. And then it's Christmas. Uh, hopefully it comes right on time as planned, as these things always do. Um, Feel free to ask another couple questions while we're here for the last 15 minutes, but I wanted to maybe touch a little bit on, I don't know, a retrospective or just how you've seen the last couple years play out. I found this Dwayne Morris. They like wrote a insight about this law, and then they had this like opinion piece from one of their lawyers right below that, which I feel like kind of speaks to what everyone has been watching Carb doing, and whether you think that these laws are overregulation and totally wrong, or if you are like Beehive and you're partially building your business based on it. We have all been very frustrated, as Wayne Morris here says, that Carb continues to, in my view, show no sign of moving more quickly to issue necessary guidance to those who are potentially required to report, and they continue to take an overly long time period to solicit input and provide critical guidance, creating additional stress and confusion. However you feel about what these laws should or shouldn't be, I feel like many of us can feel that way about what's been going on at CAR. I'm hoping you can feel free to share how you've seen the last couple of years play out, but maybe why has it been that way? Is it because this is the first time and Carb doesn't know? Is it because these are more complicated than you actually appreciate them to be, and actually these have been moving quicker than we think? Is it because the leadership there has made some mistakes, or they thought they'd have more time? Like, how have you seen the last couple of years play out in Carb's approach here, and why do you think it's taken so long? Because it is crazy to me, going back to the very first thing I put up here, the reminder timeline wise, these things came out in October 2023. They were signed October 2023. And then 2 years later, we are still not done with the regulations. And I'm sure this stuff's complicated, but like that feels crazy to
Okay.
somebody like me. So talk to me about it.
Yeah, there are two issues I would say here. One is more technical, the other is more political. But let me just run down the political side of it first. Yes, the laws were adopted and passed into law on January 1, 2024, and the chamber filed suit at the end of that month of 2024. But remember, when Governor Newsom signed them into law, he expressed two significant reservations. He said, hey, this is too aggressive. The timeline is too aggressive. And um, he didn't put it this way, but everybody got the message. We think that scope three requirements are probably too much. And
Mm.
legislature, we want you to take this up in 2024 and go back to the drawing board on these two issues. And he drove that point home with his proposed budget in early 2024, in which he gave zero funding to ARB to implement the laws. So ARB didn't have funding to hire staff to do anything in 2024. Unfortunately for the governor, Senator Scott Wiener was made the chair of the budget committee in the Senate. And so he was able to push back against the governor and ultimately got significant funding for ARB to implement the laws. He also resisted very, very strong political lobbying to amend um, 253 in particular to A, to extend the deadlines, and B, to get rid of scope three reporting requirements. And notably, so the Chamber of Commerce weighed in, the governor weighed in, and notably ARB weighed in. They actually submitted proposed amendments to 253 that would have done away with scope three reporting. So there is a definite element within ARB that's not comfortable with some of these requirements, in particular the scope three reporting. So that may be a factor. I'm just saying that maybe because this is political speculation, but that record is clear. And so the end of 2024, SB 219 was adopted into law, which tweaked 253 and 261, gave them an additional 6 months to implement the laws, but didn't make any of those more fundamental changes. Okay, so that's kind of the political thing. You could read into that that maybe ARB isn't comfortable with all of these requirements and is slow walking some of the implementation. I don't read that. I don't think that's the case, but that's a possibility. I don't think that's the case. I think the bigger explanation is um, look, they just started hiring staff in late 2024 for this, and they had, I think, what, 42 positions that were authorized. I mean, quite a lot, or 28 positions, I believe, is authorized. So, I mean, it's a big lift. It's a big lift for the agency. So, and you've got a lot of new staff that are just brought on to do this, and it's not easy. And in fact, we have seen over these three workshops them take different positions each time, right? Which is a little frustrating for the regulated community. It's like, what is doing business in the state? Well, we find out three different answers. You know, they're inching towards clarity. I think they're getting towards something that's going to be an actual proposed regulation. But yeah, no question, it's been frustrating. And I think it's probably been very frustrating for them as well, because they're kind of having to work it out, figure it out as they go with largely new staff. Not easy. And though also you have to understand the larger context. ARB is doing a heck of a lot right now on climate. You have the LCFS regulations, you have the cap and trade regulations, you have the legislature, the negotiations with SB 1090, 1207 extending the cap and invest program. There's an awful lot on ARB's shoulders right now. They are stretched very, very thin to try to do all this. So it's a big lift in itself, and it's an even bigger lift given the larger context of the multiple, was it, we're up to 46 lawsuits between the state and the federal government now, many of them on climate issues, which involves ARB. So there's just an awful lot going on. And under these circumstances, it's very frustrating. It's very frustrating as I advise clients because the things keep changing and trying to figure out where they're going to go is very hard to figure out. Again, I think we're inching towards clarity, but it's understandable given the situation. And I'll just finish by saying it remains the case that of all the guidance that ARB has issued, the most important is the one that they issued first in December of 2024, and that is their enforcement discretion notice saying, guys, if you make a reasonable good faith effort, we're not going to ding you. And that's essentially, and I think that they will stand by that because they will take enforcement action. I guarantee you they'll take enforcement action against those companies that refuse to comply. And there will be some of those. And so those are the examples that they will seek to make, not to say, yeah, you missed a comma here,
Mm.
not those kind of fine-tooth efforts.
Yeah. Yeah. Um, that's super interesting. Oh, Mr. Scott Wiener. We actually did an event with Scott Wiener in person in San Francisco almost a year ago, December something 2024. And the points he made a year ago were very similar to the points you made now. This is not regulation. This is just asking for information. The law is the law. We are funding this. They can push back all they want, but we're going to fight that. It was a lot of like, you know, I don't think he saw this getting pushed back again and again, but he really forcefully stood up for these laws, and we'll see how they turn out. Maybe he bit up more than he can chew, or maybe he'll be the next governor. Who knows?
Oh no,
There's
he's
a
running
great
for the House.
the road to the House. That's right. He's running for the House. Governor in a couple years. Um, he's very tall. California has very tall governors. There's a great final question that somebody asked that was on my mind as well. But I'm hoping, Nico, as we finish up here, this has been super helpful. A couple people have chimed in saying thank you to you. So thank you from me and from all these folks here. Um, by the way, Nico, very handsome head of hair. I'm saying if the camera's on, just would have been a show for you all. But last question here is: can you put all this in the context of other states and other countries? So the question specifically is: as we look to the future, can you speak about how other states are paying attention to the current situation as they draft their regulations, specifically referring to New York? If I'm a company and I'm like, Nico, I'm pulling my hair out here. Will they? Won't they? California? Not California? And you're going to come to me and say, look, California is one piece of this puzzle. Draw the rest of the puzzle for me. What else is out there? What should I be paying attention to?
Well, you mentioned the one that is most compelling, and that is New York's. And I'm not in New York. I have a colleague in our New York office who's following it more closely, and so I don't know, what the odds are, when it will go into effect, et cetera. But it's closely modeled on this law, and I think the odds are that it's going to be adopted and it's going to go into force. So um, this has been we're going to see that. And I believe that I think Illinois is taking up a similar piece of legislation. I expect that several of the blue states will follow course and adopt similar laws. So I think that is going to be a trend. It's a way in our polarized country. It's a way for these states to push back against the Trump administration. So I would continue to expect that. Europe is a whole different situation. They're in the process of pulling back on their disclosure requirements. We don't have the new final rules yet, but bottom line is those requirements, which were much more extensive than California's, are going to get pulled back to some degree. How much we'll see. But Europe is really facing a lot of heat. I was just at COP30 in Belém in Brazil, and I tell you, one of the subtext for that event was CBAM. And Europe is getting a lot of heat around the world for its climate programs. And this is an aspect of that, and they are a bit in retreat.
They were interesting. I didn't know you went to COP. We would have made that part of the chat. But I appreciate it. Nico, thank you so much for always being a resource to us. I really appreciate it. Um, Folks, Nico Van Alstein, I'll send you a note. I'll send you his profile. Works with Shepard Mullen, fantastic advisor to many. So I appreciate you, Nico, very much. Everybody, good luck out there. Call your lawyers, and if you don't have one yet, call Nico. Um, and we'll provide whatever updates we can. But thank you all very much for joining. I hope you all have a very happy Thanksgiving, and we'll talk to you soon.
Thank you all.